This has, I think, been held for 40 years that affirmative action has been in place. Now they have upended that. Stare decisis, as you attorneys call it, it's no longer in this case. What do you make of this decision and what it means to those going to college now and to the universities themselves?
Well, I don't think we can even overstate the role that race has played in our society as a country. And it also is a very big part of one's identity. And so part of the college admissions process is the practice of a student, a potential applicant, detailing why they believe their identity and being ought to be an additive addition to a particular school. Now, it'll be very hard for an admissions process and an admissions office to delineate between how a student views themselves and their identity and what can now be considered in practice. An example that came up during the Supreme Court oral arguments is the idea of, well, what about a student who is writing about their personal identity as it relates to their race? Is the admissions office to look at that essay, burn it, throw it out and say, I cannot see this here because it deals with race? And I want to read for you a quick notion here. I know we're short on time, but the monumental consequence of this decision cannot be overstated. Everyone from Apple to IKEA to Starbucks joined in briefs to talk about racial diversity, improving decision-making by increasing creativity, communication, and accuracy. Some of the largest law firms in our country spoke about the private bar and the legal profession benefiting from a diverse pool of talent from which to recruit. Retired admirals, a group of them, and generals also told the court that, quote, diversity in the halls of academia directly affects performance in the theaters of war. And so for those who believe that the confines of affirmative action in the decision is going to be here and only in the halls of Harvard or perhaps University of North Carolina, you have these amicus briefs and details about the impact more broadly and the potential domino impact of this decision.
All right, Laura, stand by for a minute, because obviously what is going to matter now that we know that the courts have basically overturn the idea of affirmative action or considering race in college admissions is how they state it specifically. What are the parameters, the exact language? Let's go back to Jessica Snyder, who's got some quotes here. Jessica, what have you learned?
So, John, that's key because this opinion does contain a bit of nuance here. Broadly, colleges and universities, they can no longer have applicants, check a box that says which race they are, and they can't expressly consider the race. However, within this opinion, which is a 6-3 opinion led by the conservatives, they do say that nothing in this opinion should be construed as prohibiting university from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. So that indicates, and that was a question that did come up at the arguments, can applicants mention their race at all in their essays, in other things that they submit, in letters of recommendation and the like? Okay. This is saying that in a broad sense, universities can look at race when it pertains to how it has affected someone's life, but they can't really have someone check a box saying exactly what race they are. So in the broad sense, they're saying that the way UNC and Harvard and other colleges and universities across the country have operated up to this point, they say that that violates equal protection, but they're not completely banning universities and colleges from considering race in the broad sense, and particularly how someone's race has affected their life. So what's interesting here, we are waiting for more dissents from the bench because so far we've just been hearing from Chief Justice John Roberts reading parts of the opinion. But I will tell you that Justice Sonia Sotomayor has written a fiery dissent here where she says that these rules, this rolls back decades of precedent and progress. She says that this will have a devastating impact. And that's something that throughout the months of covering affirmative action, devastating impact is a theme that came up again and again. These universities have already told the court in amicus briefs, even the universities in California and Michigan who haven't been allowed to use affirmative action for years, they say that there really is no substitute for affirmative action. They've tried to diversify their campuses, but they say in large part they've been unsuccessful in using other race-neutral methods. So Justice Sonia Sotomayor putting a point on that, saying that she believes this will have a devastating impact, but obviously a 6-3 decision telling colleges and universities you can no longer explicitly use race as a factor in your admissions policies.
And let's dig into this. Jessica, thank you for pointing this out. Continue digging through it. I found that it's page 39, Ellie, is where she's reading from, and I was looking at it. The words matter, and the Chief Justice wrote this opinion. Let's read them, because it's important. At one point, he writes here, both programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. We have never permitted admissions programs to work in that way, and we will not do so today. At the same time, as all parties agree, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise.
So that's a crucial passage, because that gives some guidance on what is still in play. And again, the key term here is what we call race-neutral factors. So we're not checking boxes. Students are not required to say what race they are. And one of the things the Supreme Court objects to, and was objected to in oral argument, is giving a specific numerical bump based on race. However, there still are things, as the passage you just read, Kate, makes clear, that colleges can do to try to generate diverse classes for themselves. For example, you can look at what's in a student's essay. You can't restrict what students write in an essay, and yes, colleges can consider that. There are other race-neutral factors. Economic background, is someone first generation, that colleges can take into effect. What I think is really interesting is there is a recognition here, even in the majority, which is striking down affirmative action, that racial diversity is a virtue. It is a value. They're not saying it's a bad thing or it's meaningless. The question is, what are the constitutional means to get there? And that's sort of the dilemma that they're really grappling with here.